Vusimuzi Matlala is allegedly the mastermind who paid gunmen who are his co-accused to attempt to kill his former partner, Tebogo Thobejane. He has continuously denied that the money paid to the accused was for the shooting, saying it was for funeral arrangements.
There is no direct evidence that links him to it. My own friend herself said, in open court, she said, there's no smoking gun here. All we rely on is circumstantial evidence. And yes, there have been convictions on circumstantial evidence, but it gets a bit much, my lord, when there's so many cases and everything is relying purely on circumstantial evidence.
The defense has argued that the Alexandra Magistrate's court applied the wrong schedule for the matter when deciding on bail. Both the defense and the state have conceded that it falls under Schedule 5 and not Schedule 6.
Our case is that he did satisfy the onus in terms of Schedule 5. That onus being that the interest of justice do permit his release on bail. There was nothing untoward or suspicious in his conduct. He had always cooperated with the SABC and RDEC. He had always appeared. There was no instance where they had requested him to appear and he hadn't.
Magistrate Saida Prinsloo had previously maintained that Matlala would interfere with witnesses. The state has argued that the cell phone, which was found in his possession while in prison, and his falsified Eswatini identity card prove this.
That cell phone in prison is a means to communicate to the outside world. And that is a risk to the state's witnesses. That is a major risk, as it is, my lord, by the very nature of these crimes. By the very nature, these witnesses are in fear for their lives, and rightfully so. So, my lord, the fact is that the behavior of the appellant is not that impeccable.
Matlala has denied owning a private jet and a boat in Mauritius. The prosecution insists that the father of 9 cannot be trusted and has not always been forthcoming with the court.
It was indicated that there was, in fact, evidence of a trust entity established in Mauritius where the appellant has an interest in it. So what does the appellant then do when the bail application eventually proceeded? My lord, he then suddenly discloses that fact, which he did not do in his initial affidavit. And it was only upon the fact that he was, I will use the words, caught out, that he's got an interest in a trust entity in Mauritius. It was only then that he disclosed that fact to the court a quo.
The state has told the court that once centralization of other dockets is complete, Matlala would face 11 charges of attempted murder. Matlala's legal team has proposed bail of 100,000 rand and house arrest. Judgment has been reserved. Neria Hlakutsa, SABC News, Johannesburg.